All right, I think we will get started so we can keep everybody on time and we can get you out of here so that you can go enjoy what I think is going to be the last nice day that we have this year. It looks like it's supposed to be winter basically tomorrow. So I hope everyone gets out there and enjoys it after this webinar. So we'll be quick, but we'll be effective also. So thanks so much for joining. Appreciate it. Today we're going to talk about New York State paid sick leave, which is a really fun topic. I'm sure everyone has already enjoyed trying to figure this out to some extent this year. We're going to cover a lot of information in this webinar and a lot of detailed information. So what I would recommend is that you take some notes on any questions you have about topics that we cover. And there'll be time for a question and answer session at the end of the webinar. But also, if you're uncomfortable with that, or from a time standpoint, you don't have time to do that, you can certainly reach out to me afterward, and I'll plan to reach out and follow up with all of you to set up a time to chat about any specific questions you have for your business. So we're going to go over what the law is. We'll also talk about that pretty useless FAQ document that New York State issued this week on additional answers that people have had on this law. And then really, we're going to talk about a lot more practical, tangible tips for how to integrate this into your business to be compliant and what you should consider. Because it isn't as simple as I think all of us expected it to be when we knew that this law was coming down the pipeline. So my name is Emily Martin. I'm the founder of Ally HR Partners. We are a new HR services consulting provider in Buffalo. So I have over 10 years experience working in various industries with various business sizes, including additional consulting experience. And I've already covered this New York State paid sick leave topic with dozens of businesses in Western New York of all different sizes and industries. So I would be surprised if there's anyone in New York State that knows more about this than I do. And I've pretty much seen every single circumstance for businesses with situations and needs to integrate this. So hopefully the information and from the experience I've gathered today will be able to help you in your business and answer some of those questions that you have. And then there's my contact information, which I'll show again in the presentation if you have follow-up questions afterward. All right, so starting with the basics here, which I'm sure most of you already know, but we'll start with basically what is this law? And it is a requirement, a new law requirement by New York State that is requiring all employers, so when I say all, I mean all, to provide paid time off in the form of sick leave for all of their employees for qualifying absences. In some cases, it may be paid or unpaid depending on your size, which we'll talk about in a second, but this does apply to all employers. So if you're a nonprofit or if you, are a certain revenue size or something, it really doesn't matter. You still have to provide this time off. There's really no hiding here. And then it does apply to all employees. So again, regardless if they're part-time, seasonal, per diem, all employees are eligible for this time. So that's a pretty dramatic change from a lot of other leave type stuff that's out there. This goes into effect on January 1st. There are parts of this that have to start back to September 30th, which we'll talk about, but for all intents and purposes, January 1st is when you'll have to worry about this. In most cases, the time off will need to be paid, which we'll talk about in a second, and the time is protected just like your FMLA leave, your paid family leave, your disability, workers' comp. This is covered by the same type of protection rules. So what is this not? So I think this is important to point out as well. This is not related to COVID. So it's really actually a very confusing year for New York State to be launching this paid sick leave because obviously there's a lot of other noise around all the different leaves available for COVID related reasons out there. But this is 100% completely and in addition to the COVID leaves. So New York State does have the required paid time off for COVID. So does the CARES Act at the federal level, which in most cases supersedes that New York State leave. You do still need to, through the end of the year, through December 31st, offer paid time off for the COVID leaves through those leave laws. And then this New York State paid sick leave basically will take effect January 1st for other absences besides COVID, but will include also COVID for next year. This is not required PTO or vacation time, technically. So I put technically in here because unfortunately there's nothing to stop employees from lying about, whether or not they're actually sick or they're just using this time to go to the beach. But technically this is just supposed to be used and just intended for employees to use if they have qualifying reasons for these absences as defined by New York State. And then just the last point, as I said before, this is not optional. There are really no caveats anywhere in the law that say it doesn't apply to certain employees or certain employers. So this unfortunately is required. So sorry, no magical new information on that front here. So who does it affect? So as I said, everyone, all employers in New York State. Really the threshold for whether or not it's paid or not, which is the 4 employee threshold. So basically if you have 5 or more employees and you have over $1 million in net income or revenue for your business each year, you do have to provide paid leave. So if you have under 5 and you are a small enough business revenue wise, you do not need to offer this leave paid, but you still will need to have a policy in place and procedures in place to track the usage and earning of this time, because you do need to make this time available to your employees protected, even if you're not paying for it. Obviously good for you if you don't have to pay it, but it still is going to be an administrative burden for you. So again, the threshold for that is 5 employees. Otherwise, if you have under 100 employees, you have to offer 40 hours of paid sick leave. And then if you have over 100, you have to offer 56 hours, which is a pretty significant amount of time. We're talking about 7 days there. So. All right, so what absences are covered? So as I mentioned, this is not intended to be a requirement by New York State to offer paid time off or vacation time, but it is just meant for qualifying absences. So it's meant to cover mental or physical illnesses, injuries, or health conditions of the employee themselves or a family member. So that includes the diagnosis of medical conditions or mental or physical, the care for those conditions, the treatment of those conditions, or preventative care. So we're talking about doctor's appointments, we're talking about, if I wake up with a stomach ache, all of those things are covered for the employee and their family members. We're also talking about absences due to the employee or a family member being a victim of domestic violence, a sexual offense, or stalking or human trafficking. So that could be, going to the police station to file a police report, or going to court to deal with a restraining order, or things like that. Again, this is the employee and the family member, and family member is defined here. It's a pretty standard definition, but child, spouse, domestic partner, parent, sibling, grandchild, grandparent. So it's not really just like a very immediate family. It does expand out a little bit into the circle there. So again, this paid sick leave is meant just to cover these absences. We'll talk about whether that's really enforceable or not if employees lie, but this is the true intent of the law here. All right, so let's talk about, kind of what is required by this law, and then what you have some choices, to make on. So, what is required? What must you do? So you must at least offer the minimum amount of time required to all of your employees. So we're not just talking about full-time staff. We're not talking about people who are regularly on your schedule. Any employees that work for you, you do need to be giving this paid sick leave to. How much is another question that we'll cover with the accrual, but all employees that work for you on your payroll, regardless of how much or how little, are eligible for this. The minimum amount, again, is either the 40 hours in a year or the 56 hours in a year, depending on your size. The law also states that you have to allow for rollover of this time. This is one of the, most highly discussed aspects of this law. The law states that you have to allow employees to roll over any unused paid sick leave from one year to the next. However, it also states that you only have to allow employees to use 40 or 56, again, depending on your size each year. So if at the end of the first year, I didn't use 20 hours, technically I can roll it into the next year and get 40 more and I have 60, but you only have to allow me to use 40 in that year as the employer. So it's kind of like a mythical phantom balance that hangs out there. You know, it makes no sense, and there's really no real world implications to it, but that is a requirement by New York State. They did not provide additional guidance in the FAQ that came out this week on that. They did provide some, but it didn't make any more sense. So that is still a rule. We'll talk about ways to maybe get around that in a little bit. You do have to pay your employees at their regular rate of pay for this time off. So if I'm going to use my paid sick leave, I have to be paid at whatever normal rate I would be paid when I'm working. You can't choose to just pay like minimum wage for this time. You do have to allow for a minimum half-day usage, so you can't just say to employees they can only take full days off for this. They do have to be allowed to use it in half-day, which is 4 hours. You can choose less than that if you want to. We'll talk about that in a minute, but minimally half-day. If you choose an accrual method, you do have to make sure employees are earning this at a minimum amount stated in the law. And what the law states is if you're going to an accrual, so you're not going to do a dump method, that employees have to earn 1 hour of paid sick leave for every 30 hours that they work. Now, the 30-hour number is kind of confusing because if you have full-time employees, obviously they're normally working probably somewhere around 40. So instead of figuring out what that equals, you know, per 40 hours, my recommendation in doing this with a lot of clients is setting up an accrual that's based on per hour worked. You're tracking that time in your payroll system already, right? Employees are recording their time, so you know what to pay them. So that equals 0.034 hours per hour worked. So we'll get to it in a minute, but that's really the recommendation, is to set up a per hours worked accrual for a few different reasons. And then this is something that I want to be super clear about. This time must accrue on all hours worked. So if I'm your employee and I normally work 30 hours a week, but then I work 50 hours for you 1 week because, you know, you guys are behind on production or something, you have to allow me to accrue on that full 50 hours. So that means any overtime hours count. Basically, anytime I'm doing work for you, that has to be counted towards what I minimally need to accrue. All right, so these are things that are really without question what you need to be doing and what need to be in whatever type of time off policy you're developing needs to be in there. These all need to be in there. Some choices that you have to make. So you do have choices, yay, I don't know, that's kind of like a curse and a blessing. I think probably most people would just prefer that this law detail exactly what they need to do, but that keeps us HR people busy and employed. So you do have the choice of whether you want to do an accrual or a dump. So you can choose each calendar year or anniversary year, I guess you could choose also, to dump the full amount the employees need. So on January 1st, you could say all employees just get their 40 hours and they can use it whenever they want throughout the year, no questions asked. You can also choose the accrual method, which we talked about. And we'll talk about in a minute the choices between those. You also need to decide on a payout option. So one of the things the law does not require is that it does not require you to pay out employees for any unused time. So if they get terminated or they resign, you do not have to pay them out for unused balances, but you can choose to do that, especially if you have that as part of an existing time off policy and you want to integrate this into that, which we'll talk about. You may also want to consider whether or not you want to put somewhere in this policy or in your, adjoining attendance policy, whether or not you want to require employees to use this time if they're absent. So maybe you, don't want employees to be able just to be late for an hour here and there, take that unpaid, and then also have this 40 hours of paid sick time out there that they can use. So you could put a caveat in there to state that if any employees miss a minimum amount of time of 30 minutes or 1 hour or more, that they're going to be required to apply this paid sick leave. So consider that, and we can help you, developing that language in a way that's compliant. And then you need to decide on minimum usage. So as I mentioned, you have to allow people to use this in at least as little as a half day. You can choose less, and the kind of example I just gave is a good reason you may want to choose less. but you do have that choice to make. And then the big choice is really whether or not you want to integrate this into other time off policies. And I want to make that point very clear because it's something that a lot of clients don't understand or realize. And they read this law and they see this law and they get scared half to death, like this Lego guy. So that's my really terrible joke for the day of this presentation. But you do not need to offer additional paid time off as a result of this law. So I'll make that very clear and say it again. If you have an existing time off policy now, whether you're calling it PTO, paid time off, vacation time, you do not need to just give all of your employees another 40 or 56 hours of paid time off starting next year. You can integrate this law and the requirements of it into modified versions of your existing policy and still just provide the same amount of time off you have been. And that's really where, you know, kind of the nuance and the complication and like the expertise and experience from a company like mine come in, is really taking a look at that and helping you craft something that lets you do that and stay compliant without taking on the additional financial burden of offering all that additional time off. You know, I've worked with a lot of like restaurants and things who obviously have a ton of employees that work very different schedules. They don't offer paid time off to them, and now they're going to have to. And you know, there's different creative things that we can do to try to minimize that risk, which we'll talk about a little bit more. So let's talk about, you know, if you do, you know, if you don't have a policy in place now and need to put together either a sick policy or just a paid time off policy, the different choices you can make. So the first, and I guess technically the easiest, is the dump method. So that means that when January 1st comes, you just, you know, dump the full balance of the required eligibility of 40 or 56 hours into the bank of the employees, of all the employees. And, you know, you don't have to worry about it for the rest of the year, except for tracking the usage. Well, one question you definitely want to ask yourself and consider is, do you have a lot of part-time, per diem, or even seasonal staff? So if you have, you know, and if you have a lot of turnover. So if you have a lot of employees that don't work a set schedule for you, or if you have a lot of turnover and you don't know how long people are really going to last, I don't think this is the best method for you, because you potentially are going to give them way more time than you would ever need to, because they would never, under an accrual method, actually earn what, you know, work enough to earn that full 40 for what you're required to give them. So, you know, if I start the year with 40 hours, I use it all up in January and February and quit on you in March, there was no reason for you to give me that full 40 hours at that time. If I was in an accrual method, I would not have earned it, especially if I wasn't working full time, but now I just cost you all of that money. So if you have a lot of turnover or part-time or per diem staff, I do not think financially this is probably the best method for you. And we just talked about that risk of using it and running. You know, if you're in an industry that has a lot of turnover or something, you definitely want to consider that. You could still technically use an anniversary year calendar for this if you wanted. If you have an existing time off policy that is based on anniversary year, there's, you know, an opportunity to still integrate these rules and be compliant with that and keep that as is. You know, we just got to make sure that by January 1st, everybody has what they need to according to the law, but you do have that choice to make also. And then again, if you're doing the dump method, you really don't need to worry about tracking or, you know, having employees use this time or anything at all until January 1st. So January 1st is when you would dump the full balance, and that's when people could start using it. So obviously the other option is the accrual method. You know, kind of surprisingly to me, after really digging our teeth into this and talking with clients about their different needs and really trying to reduce the financial burden of this law, this is the method that we've ended up recommending to almost all of our clients. There's an additional administrative burden to it, but you know, you should be able to alleviate that through the systems that you're using. So again, if you have a lot of part-time, per diem, seasonal staff, or a lot of turnover, I truly believe this is the method that is best for you. So that, again, make sure that you're not giving people more time than what they really deserve or would have earned. The other benefit to this is kind of getting around that rollover requirement. So if any of you use an accrual method now, maybe you're familiar with this concept, but basically if you set up an accrual method, you could set a maximum balance for employees to be able to earn or carry at every time or at any time for what the law requires. So if I'm an employer and I have under 100 employees, I'm required to give them all 40 hours. So basically I would set up my rule to say that once I hit 40 hours, because based on that 1 hour for every 30 hours worked, I'm gonna hit that before the end of the year. I'll probably hit it sometime in July or August. Once I hit that 40, the system knows to stop allowing me to accrue anymore. Regardless of what I've used, I've already earned 40, so I can't earn anymore, and my balance can never go over 40. So what that means is that that balance rolls continually into the next year as well. So if at the end of 2021, I still have 20 hours in that bank, that rolls over. However, I can only earn up to that 40 again. So I can only earn 20 more before I stop accruing again. And then I can't accrue anymore for my 40 hours eligibility earned in 2022 until I use that balance down. So this allows you to still comply with the New York State rollover requirement, but it kind of allows you to get around it a bit and reduce that extra amount earned by reducing the earning amount with the maximum balance. So I know that's kind of confusing, and usually it involves a lot of explanation and walking through with clients, but for this reason, I do think the accrual method is best as well. The other caveat of the accrual method, New York State wants to make sure that all employees are starting the year with some type of balance to use. So for that reason, the law does state the accrual needs to start September 30th, so back to September 30th, if that's what you're doing. If you haven't set this up yet and you want to, don't worry about it. You can easily go back in time and look and see, how much time your employees worked back to September 30th, and then build on that balance to have it in there by January 1st. So no worries there, but just something extra to think about and worry about. Again, you could still choose calendar year, anniversary year. We talked about the accrual method already. A couple things to note here. So again, minimally, you have to make sure whatever type of accrual schedule you set up meets the requirement by the law that states I have to earn 1 hour for every 30 hours that I work. So what that means, again, is 0.034 hours per hour worked. So my recommendation is, if you're trying to just minimally meet the requirement of this law, is that you talk to your payroll or time and attendance provider and have them set up an accrual policy that accrues each pay period based on a calculation of X amount of hours worked times this 0.034, and that's how much I earn each pay period. This is probably different than what anyone's doing right now, because you're probably just kind of doing a set amount divided by the number of pay periods you have in a year. So if you have a weekly payroll, you're dividing the total eligibility by 52 weeks. So this is a little bit different than that, but this keeps you compliant. One thing that you want to make sure of if you do this and you're trying to incorporate these rules into an existing time off policy is that you make sure you cover your maximum eligibility. So if I'm including this and integrating this into an existing time off policy, and the maximum amount, if someone works for me for 10 years, they can earn is 120 hours. This accrual of 0.034 hours per hour worked is never going to get me to 120 hours. I think I'd have to work something like, 5,000 hours in the year or something. So you might just have to modify that accrual amount and calculation to increase it a bit to get them to that 120. Again, it's a complicated factor, and we're happy to work through that with you. Also, again, as I mentioned, make sure you're considering what your current payroll and or time and attendance system capability is. Most people out there either have them within the same system, or even if they're separate, any good, reputable, credible payroll company or time and attendance software provider should have a plan in place already to help clients be compliant with this, because it's been coming down the pipe for quite a while. So make sure you're leaning on them for a solution and holding them accountable to put that in place. And then finally, if you're going to an accrual method, one other thing you want to add to your list of things to consider is how you're going to calculate the accrual for exempt employees who are not paid hourly. So If you're not paying people by the hour, you're then not tracking the amount of hours they work. So how will you set up this accrual that's based on hours worked? And you should be safe to just put something in your policy that states any exempt or salaried people are going to be assumed to work 40 hours a week, and their accrual will always be based on 40 hours per week, and that amount of time per pay period. So again, the accrual method, for a few different reasons, is really the best method, the least kind of like financial burden bringing method. It does obviously offer additional challenges on the administrative standpoint, but you should be able to, with a little bit of guidance from a firm like ours and with help of your payroll provider, put together a solution that works for you and is compliant and doesn't involve a lot of headache on your end to manage. All right, so let's talk a little bit about, aside from just the actual policy you have to put in place for time off to be compliant, what some of the other ripple effects are and some other policies you want to make sure to consider that you're looking at as a result. So the first is an attendance policy. You know, companies, some of them have very well, outlined and detailed attendance policies, some don't. But you definitely want to take a look at this, because now, as I mentioned, all of these paid sick leave absences are protected. So if you have like a point system or anything like that for absences, you no longer can count these New York State paid sick leave absences toward the points or toward any disciplinary action. So you'll definitely need to take a look at your attendance policy, even if you just implement or insert a line in that states that where this policy varies from New York State paid sick leave, New York State paid sick leave will prevail. That should be okay. And then just obviously in practice, you want to make sure that you're actually following that. But you do want to be careful about this. So, you really won't be able to discipline employees for attendance until they've used what, New York State requires you to provide to them for absences. Now, if they're telling you like they're late or absent because they slept in or, they didn't want to come to work or their car broke down, those are not protected. But I think employees will wise up pretty quickly and know what to say. Again, consider required usage. If I was an employer, I would want my employees to be using this time down as quickly as possible so I could predict it better. So I would be putting something in my attendance policy that stated, if you're absent for any reason, we're going to apply this paid sick leave or paid time off, and you'll get paid for it, but you won't have it later to use for other absences. And then it gets you to the point more quickly where you can discipline for those absences too, because they've used all of their time. A big question that's outstanding still from New York State, even with this FAQ that came out this week, is documentation. So, whether or not you can require employees to provide proof that they actually, took this time for a qualifying absence. The law is fairly silent on this. So if you have something in your handbook now that states that they must provide this time or this documentation for time to be approved or excused, you probably want to remove that from your handbook. At this point, I would say I've seen other leave laws out there for like New York City and for like Arizona that state if someone's absent for 3 or more days, you can require documentation. So maybe that's a better kind of rule to go by. But right now it's still very much up in the air of what you can really require. And then, you want to make sure you have other language in there that's required. You really probably should just have a New York State paid sick leave policy in your handbook, even if you're combining the time with other time off. You want to make sure there's a section that clearly states employees' rights. You can't retaliate against employees for taking the time, the fact that it's protected and all of that stuff. Again, we have templates for all of that and can certainly help you put something together. And I already mentioned the generic caveat statement in this policy. So again, this law does have ripple effects to other things, so just make sure you're going through your handbook and addressing anything that causes a discrepancy with this law. That also includes leave policies. So other leave policies, I guess, aside from paid sick leave. So FMLA, disability, workers' comp, paid family leave, similarly to the question or the choice you have to kind of require the use of this time off, this paid sick leave for absences, You may want to consider putting something in your leave policies stating that for any unpaid portions of leave, employees have to use this paid sick leave. I haven't seen anything that says that's not okay. It's, you know, been okay for all of time to do with other to do that with other types of time off. So again, something you want to consider as well to kind of manage the amount of time people have available to not be working for you, right? And then other things you want to consider, you know, if you have employees in other locations, specifically in other states, I guess even, you know, other cities as well, this might be a good time to do some research on whether or not you're supposed to be offering paid sick leave to those employees. This law only applies to your employees that are in New York State, but you know, there may be people in other states that you were supposed to be providing this leave to that you're not. For example, I had a client who has a bunch of employees in Arizona. Upon, you know, doing this, finding this out for New York State, they realized that they should have been doing this in Arizona for the past 2 years. And so we had to help put together a policy for that as well. Like I mentioned, New York City has had this type of leave in place, or this paid time off in place for a couple years now. So if you have employees in New York City, be aware of that also. And again, we can help do that research and look into all of that for you if you need the help. The last thing to really consider is record keeping. So as I mentioned, I want to stress this as much as possible. You should be relying on and pushing your payroll and your time and attendance providers, or like an overall HRIS provider, right, to help you find a solution for this that is going to reduce the administrative burden on you. Again, so I don't know if you're using ADP, Paychex, whoever it is, they should be well prepared and well educated on this by now, and they should be able to help you put something in place that is compliant. So if you're uncomfortable doing that, that's something I'm happy to do, because I see all too often these providers are charging their clients way too much money and not offering them any level of service, and I think that's criminal. So certainly we can help with holding those people accountable also. You are required, it does state in the law, you're required to track and report usage to employees on their pay stubs. So again, something you want to make sure your provider is doing for you. I'm sure most of you aren't doing your payroll in-house. That can be electronically within, you know, any system that people can log into as well if you're not doing paper checks and stuff like that. But that is a requirement also. And then finally, you know, you do want to consider not having just kind of like a generic time off or paid time off code in your payroll system to code for, like, you know, holidays and bereavement and paid sick leave and vacation all the same if you don't combine sick leave and vacation. Because if you're ever audited and you have to prove that you gave an employee the amount of paid sick leave you were required to for their qualifying absences, you want to make sure that you can show that you did that. So having a couple different types of time off codes in your system, again, should be something very easy for your provider to do. It requires a little bit more time on your end or the manager's end to make sure that it's coded properly, but it might be worth it in the long run if you're audited, because I'm sure there are going to be audits. So closing up on the recommendation part, just some pro tips. Again, I've worked with dozens and dozens of clients in all situations and all company sizes and industries on this. And these are really the biggest takeaways that I've kind of come to with that. Again, go to an accrual-based system if you have high turnover and many part-time or per diem staff. Again, it will reduce the amount of financial burden you're taking on to not give people more than you should give them if they leave or they don't work enough hours for you. And it also helps you get around that rollover rule. I strongly believe you should integrate this with vacation, PTO, or any other time off policies you have if possible. You know, if you don't need to give everybody another 40 or 56 hours of paid time off, like, don't do that. That's a huge amount of money for your business. And it's not really that hard to do it if you are working with someone that knows what they're doing. So definitely do that if you can. Other things to consider, you know, maybe you have PTO policies now for just full-time people, or vacation policies or vacation time for just full-time people, but don't offer it to part-time staff. Now, remember, that doesn't mean you have to give all those part-time staff vacation now. You could just implement a straight-up paid sick leave policy for part-time people and then modify the PTO or vacation policy of your full-time people to meet the paid sick leave rules with a couple different pieces of language and then be compliant. So again, it's really going to be circumstantial based on your individual business, and there's, you know, ways that we can really take a look at things and be super precise and strategic about making sure you're compliant but reducing the impact on your business. Push your payroll provider for a solution. Definitely should be able to help you with that. Another tip or something to remember, you do need to roll out a policy addendum to your staff before January 1st for this. The law does require a certain amount of notification, and you do need to let people know of their rights. So you just want to at least issue some type of like memo or email to your staff when this goes into effect. And then if you've been considering changes to your time off policies, you know, before this, maybe they are just like administratively really burdensome to track. I've seen clients that have like sick time and vacation time and personal time, and you're trying to balance and, you know, keep track of all these different types of time off, when in reality, people are just using all of them for anything, which is totally defeats the purpose of having the different time. You know, maybe you want to consider now going all to a PTO bank or doing something and making some change that, you know, makes it less time consuming for you to deal with. So because this law is coming into effect now, maybe you want to consider blowing up the whole thing, and I think it's a good time to do that. We already talked about that bullet, and then, you know, in the end, you want to make sure you're at least compliant. So New York State is considering this to be just as important, or they're enforcing this to the degree, or will plan to, the same way they do all wage and hour law, which means there's probably going to be a lot of audits, and also employees, if they complain that they're not getting this time, you know, they're going to respond pretty quickly to those complaints. So you want to make sure you know what you need to do and that you're at least putting that policy into place. As I mentioned, there's still some questions out there specifically about like the rollover and the documentation that you can require. So information is still developing. You know, it was really disappointing to see that FAQ document earlier this week, because I really have no idea where they got those questions from, but they definitely aren't the questions that I've heard people asking, and they left a lot to be desired there. So hopefully there'll be more guidance before the end of the year. But here's a couple things that it did mention to us, which aren't really much different than what you already saw in this presentation. But one of the things was, you know, what are the penalties if you don't comply? And as I mentioned, they're really looking at it the same way they're looking at, like, if you fail to pay your employees minimum wage or fail to pay people for the time that they worked. So the penalties for that are pretty much, you know, up for pretty great debate. And pretty limitless. So you might owe back pay, liquidated damages, civil penalties, depending on how egregious they determine your non-compliance to be. Those can be whatever they want them to be. So make sure that you're complying. The FAQ also affirmed the issue with the front loading. It actually recommends that if you do have employees that you can't really predict what they're going to work, that you don't do the front loading, because you'll have to just track the time anyway to make sure that they get what they should. And then one thing that was interesting is the FAQ did add a specific line to state that employers are well within their rights to discipline employees for abuse of the paid sick leave or for lying. Again, I don't know what like the burden of proof would be if you were to like terminate an employee and then they were to claim like retaliation or something, how you would prove that they lied and weren't actually using the sick time. Maybe if you had like a Facebook picture of them like at the beach when they're supposedly sick. So I'd be careful with that, because as we know, New York State is always sympathetic to the employee. But it is interesting that they put that in there, and maybe it's some type of glimmer of hope that they will, you know, be on the employer side with that stuff. So just additional reminders while I have you as a captive audience. This is a major change as we go into 2021 and get to the end of 2020. And as we do that, there's a couple other things that you want to keep in mind, and things that, you know, we can also help assist with if you are unsure how to deal with. But first is New York State harassment training. Again, as we all know, that wonderful law was passed a couple years ago. You do still in 2020, even with COVID, have to provide the New York State sexual harassment training to all of your employees by the end of the year. So if you haven't done that yet, we have a really cost-effective solution to do that, so we can provide that. A reminder that minimum wages are increasing again this going into 2021. That's both for hourly employees and for salaried employees. So you want to make sure to take a look at all of your wages and make sure that you're increasing those or changing the exemption status of your staff if you're going to be below those thresholds. A reminder, this is probably something that's going to fly under the radar a bit because of COVID and leave and things, but New York State paid family leave is changing for 2021. So it's going up to, instead of 10 weeks of available leave, to 12 weeks. And it's going up to 67% of pay that employees will be able to get for that leave. So again, New York State paid family leave is available to employees to be able to care for family members if they're sick, or most commonly it's taken for women after they have children to care for and bond with their children. Voting leave law, election day is coming. I know we're all dreading that. Remember that you are in certain circumstances required to provide paid time off to employees to vote. And then a reminder here, this probably doesn't affect many people, but the tip credit that you can apply to employee wages is completely going away for 2021 if you're in non-hospitality. So again, if you're in like hospitality restaurants and things like that, obviously you can still pay the tipped minimum wage and apply the tip credit. But if you're in another industry like salon, or like I always think of Delta Sonic Car Wash, you no longer will be able to take the tip amount off of your requirement to pay employees at the minimum wage, which is going up to $12.50. All right, so just a couple other things to keep in mind. So remember that we are here if you need help with any of these things, so any of the paid sick leave stuff, which is super complicating, and any of those other items I just mentioned, or really anything else. If you have a major employee relations issue on your hand or an issue with COVID and your employees, there isn't really much that we have not seen. So I'm confident that we'd be able to provide you some comfort and peace of mind if you just want to give us a call or shoot us an email, and we'd be happy to help you through that. So that is all. Thank you so much for attending. Again, we're a new business, so all of your eyeballs are greatly appreciated, and I hope you found this helpful. We will post this presentation on our website after, so you can watch it again. And again, if you have specific questions, you can certainly reach out or give me a call by email, or I'm sorry, give me a call or email me if you have questions. So if you have questions now, though, I'm happy to take them. I think you should be able to unmute your mic by clicking on the mic button, and I can answer any questions that you have. Don't be shy. No questions at all? You guys just anxious to get out there in the sunshine, huh? All right, well, I will follow up with each of you and see if you have any, but certainly let me know as well. And again, this will be posted on our website. So thank you very much for your time today. Thank you for attending, and good luck to you all toward the end of the year.